So what the heck is the purpose of copyright anyway? Among world legal traditions, there are two overarching rationales that justify most nations' copyright laws. A utilitarian rationale argues that copyright incentivizes creators to make new works, the argument being that most works would be copied without creators' proper compensation for their creative contribution. A second rationale is that of authors' rights that argues that copyright ensures attribution for authors and preserves the integrity of creative works. Simply, without copyright, there would be nothing that ensures a creator's contribution is acknowledged and their creative vision can appear as they intend. So what is it that you can copyright? In countries that have signed onto the terms of the Berne Convention, copyright can cover literary and artistic works, translations, adaptations, arrangements of music, and alterations of literary and artistic works, as well as collections of literary and artistic works. In some countries, copyright can be given to applied art and industrial designs and models, as well as computer software. In contrast to copyright, the other two main types of intellectual property rights are trademark and patent. Trademark protects the public from being confused about the source of a good, service, or establishment. The holder of the trademark is allowed to prevent uses of its trademark by others if they believe the public will be confused about the source of the good. Patents, on the other hand, give inventors a limited window to profit from their inventions. Patents typically give inventors the exclusive right to make, have made, use, have used, offer for sale, sell, have sold, or import patentable inventions. Other forms of IP include trade secrets, publicity rights, and moral rights. Now, the Berne Convention mandates that copyright must be granted automatically as soon as a work is fixed in a tangible form, without registration or other legal formalities. But when the terms of the copyright expire, the work enters what is called the public domain. In most cases, you can do almost anything with works in the public domain. However, it is important to note that works in the public domain in one country may not necessarily have entered the public domain in others. Additionally, works may have limitations based on other intellectual property rights, say a book carrying a trademark. Additional works that may be part of the public domain include works never protected under copyright, works dedicated to the public domain before the copyright has expired, as well as situations where the copyright holder failed to comply with formalities to acquire or maintain copyright. This isn't to say that the only way to use a copyrighted work is after it enters into the public domain. Copyright law also has exceptions and limits. The most well-known of these exemptions is fair use, which the Berne Convention establishes as reproductions of such works in certain special cases, provided that such reproduction does not conflict with a normal exploitation of the work and does not reasonably prejudice the legitimate interest of the author. This is often referred to as the three-step test. Other notable exceptions to copyright in many parts of the world include criticism, parody, and access for the visually impaired.